Okay, we are now recording. Welcome to Bankruptcy Basics for Mediators. This program is designed to give some very basic understanding of concepts and processes to help mediators when bankruptcy issues are either overt or lurking. So how could that come up? Well, one of the ways that bankruptcy issues can come up in mediation is where a party tells you that they're weighing bankruptcy as an alternative to settling the case. Another could come up where, let me put this in a slideshow. Sorry about that. Another could come up where a bankruptcy filing has already occurred by a party or by someone they're affiliated with, or they could have already gone through the bankruptcy process and gotten a discharge in bankruptcy, or perhaps they did file bankruptcy but got kicked out. So all of these things could happen, and I will tell you that the first three I have already encountered just this summer, and I'm expecting this to happen more often. Generally, bankruptcy is what we call a lagging indicator, so that when there is an economic shock, it takes some months for that to start impacting bankruptcy filings, and it looks like they are starting. And I'm hearing a lot more about bankruptcies from folks these days than I did when I started mediating here back in the beginning of the year. Now, bankruptcy is complex. You'll hear me use the word broad a lot because that's a really good description. Once you get into it, it covers, every possible aspect of the economic life that touches a creditor. It has very powerful tools in it that you need to respect, but it's also honeycombed with exceptions, and the exceptions have exceptions. It's that kind of statute, so it can be very complex. The main things to remember about the Bankruptcy Code is there are two goals that it really serves. One is to give the unfortunate but honest debtor a fresh start. The fresh start is a critical principle underlying the Bankruptcy Code. The second is to provide equitable distribution of assets to creditors so that you don't have the fastest creditor goes in, dismembers, whatever there is to take, and everybody else is left with anything else. The idea is that it's going to be an equitable distribution according to the priority system that's set forth in the Bankruptcy Code, and similarly situated creditors are treated similarly. Now, I'm not trying in this presentation to delve into all the intricacies of the bankruptcy process or make anybody bankruptcy experts. As I said, it is complex, it is broad. I'm going to have to use the word generally a lot because there are lots of things that happen in bankruptcy court that are, in much more sophisticated arenas that you probably won't run into, and that would take way too long to ever get into, like free and clear sales in Chapter 11. So we're not going to get into any of that. But I'd like to leave you with an understanding of the basic terminology in bankruptcy. So when it comes up, you'll get your aha, bell coming on so that you know that people are thinking about this. And have a general understanding of what kinds of issues come up, and to try to avoid contributing to things like violating the automatic stay or the discharge injunction, which can have very serious consequences. Now, bankruptcy authority comes from the Constitution. There's an express authorization in Article 1, Section 8 that gives Congress the power to establish uniform laws on bankruptcy. So Congress, when it has an express power in the Constitution, is legislating at its highest degree of power. So it is able to establish fairly broad-ranging legislation, and that is what the Bankruptcy Code is. Bankruptcy courts are different from other federal courts. We don't have judges appointed for life by the president with the advice and consent of the Senate, like district courts and appellate courts and the Supreme Court. Instead, the courts of appeals for the 11 circuits and the DC circuits appoint the bankruptcy judges within their circuits for 14-year renewable terms. And the bankruptcy districts are in 90 of the districts that we have for federal district courts. There are 4 district courts that just handle it themselves and didn't create bankruptcy courts. But here in Florida, we have bankruptcy courts in all of our federal districts, and the one for us, if you're mediating a case and someone goes to bankruptcy, they're going to be in Tampa at the Bankruptcy Court for the Middle District of Florida, which is under the U.S. District Court there. So that's our local bankruptcy court. One other player you should be aware of at the Department of Justice There is an office called the Office of the U.S. Trustee, and they have an administrative role in bankruptcies, things like appointing trustees, maintaining the panels, looking at qualifications. They convene meetings of creditors, and they may appear in bankruptcies where they have concerns about administration and things like that. So they are an important player in bankruptcy, although more so in the bigger complex ones. Now, the bankruptcy petition is the first thing that happens in a bankruptcy code. You file a bankruptcy petition, and that has an enormous impact on the debtor's world. First of all, it divides the world into two temporal pieces. So you will hear the term pre-petition and post-petition, and that just means, claims arising and assets existing at the moment that the bankruptcy petition is filed, and post-petition afterwards, everything else. So usually a bankruptcy claim is going to arise from pre-petition activity. There are exceptions, for example, administrative claims and things that happen when the bankruptcy court allows a debtor to reject a contract and they get a claim. But in general, we're talking about things that have happened, activity that happened that gives rise to a claim, whether it's an accident or the execution of a contract or provision of services that happen. Pre-petition, you're going to have claims there. So the other thing to know about when a bankruptcy filing happens, and this is important when people are trying to draft settlements with people that they think might file bankruptcy, is that you can't put into a contract, if you file bankruptcy, everything's null and void. If you file bankruptcy, this happens to you or that. That is known, for those of you who like to have long Latin phrases, as an ipso facto clause, and those are not permitted. So if you want to kind of bankruptcy proof an agreement, there are things that you can do, and we'll talk about that much later when we get to the avoiding powers. But this is something that I and my agency spent a lot of time doing when we were entering into agreements with companies that had dumped their pension plans on us and owed us, millions or even billions of dollars. Now, there is an exception to this prohibition for personal services contracts, because the idea was that there's a different kind of entity that's in charge once there's a bankruptcy, often a trustee, often not necessarily, and you shouldn't force someone who's doing personal services to do services for someone that they didn't initially contract with. So there is that exception. But the important thing to know is that you don't want to be working on agreements that say if you file bankruptcy, the world explodes. You just can't do that. So here are some key terms that I want to make sure that everyone is familiar with. These are the basic sort of bankruptcy terms. The debtor, which is fairly obvious, and I'm going to go into each of these as we go through the slide deck. The estate, which is what's created when a bankruptcy petition is filed. Creditors and claims, which is a very broad category that we'll talk about very soon. The automatic stay, which I am hoping that I will be able to get across to you how not to violate. Ditto with the discharge. We'll talk about exceptions to the stay and the discharge, the various chapters of bankruptcy, which have very different terminologies, and finally the avoiding powers, which is important to know about in drafting settlements where someone looks like they may be thinking about bankruptcy. So let's talk about some of these definitions. Well, when you file a bankruptcy, you create an estate. And the estate is basically, although not always, depending on the chapter, what exists at the time of the filing. In some chapters, it goes beyond that. But property of the estate is what the bankruptcy laws are largely concerned about, because that is where creditor distributions come from. If something is property of the estate, it is potentially available for distribution to the various creditors. But it is defined differently under the different chapters, and we'll get to that. The debtor is the filer. So usually individuals who are filing liquidations or Chapter 13s. In Chapter 11, the reorganization chapter, usually used by businesses, you don't use the term debtor, you use the term debtor in possession. Property of the debtor is different than property of the estate, but it's also protected by bankruptcy law. And what's that? Well, exempt property. So there is property that a debtor owns, but that is protected by creditors. What's it protected by? It's protected by either state law or federal law. So for example, Florida is very famous across the country for having an unlimited homestead exemption. So if you have a homestead and you have equity in it, no matter how, if even it's a $100 million estate, and you've homesteaded it, that is exempt property. Under federal law protects retirement accounts, under the Employee Retirement Income Security Act that I used to administer. So there are different laws that can protect property, and creditors are not going to be able to touch it. So creditor is anyone with a claim. And here comes me telling you something is broad again. Claim definition, very broad. So here's the definition: a right to payment, whether liquidated, unliquidated, fixed, contingent, matured, unmatured, disputed, undisputed, legal, equitable, secured, or unsecured. So whether you just have filed a lawsuit against somebody or have a judgment, or they just owe you payment for something that you've just sold them, all of this, or you have collateral, all of that stuff. They're all claims. Even a right to an equitable remedy for breach of performance, which basically means if you have a contract that says that money damages are not sufficient, and I get to go to court and compel you to, for example, turn over this piece of property if you don't do it, but it also says I get damages if you don't do it, then that's a claim too. So almost everything that you can think of that has an economic cost to a debtor is going to be a claim. So let's talk about types of claims, because that is really, really important. So priority claims are those that get paid before anybody else. So priority claims do tend to get paid. And family law claims tend to be well protected. So support obligations that arise before the filing are priority. Administrative expenses of the case. In order to be able to do a case, you need to be able to pay your trustee. If you're in Chapter 11, you're going to be paying lawyers and financial analysts and who knows what. It can get very expensive, and they all go before all the creditors. So priority is a really good place to be. Next up in the lineup is a secured claim, which is also a good place to be, and that's when you have collateral. So, the mortgage holder, the car loan holder, if you're factoring inventory, then you've got collateral. And you might be oversecured so that you're really sitting fat and happy and you can ride through because there's more than enough value in the collateral to satisfy your claim 100%. However, if you're undersecured, so the collateral's value is diminishing, let's say a housing bubble has just burst and you've got some buildings or whatever, then the portion of your claim that isn't secured anymore is just an unsecured claim and goes to level 3, which is unsecured as everybody else except the equity holders, and usually taking cents on the dollar for your claims. Unsecured is not the greatest place to be, but equity is the worst. So shareholders are last in line, and that's what the risk premium is for. Shareholders get a risk premium because if the company goes under, boom, they get nothing. At the end of the day in a reorganization, you may sell the company to somebody, or the creditors may end up, the unsecured creditors might end, or the secured creditors might end up owning it, but equity is generally going to be, wiped out. And, you see that all the time in corporate bankruptcies. So now we are going to talk about the big stick. That is the automatic stay, which is a very big stick and something to be really aware of. So the automatic stay arises by operation of law. The judge does not have to issue any orders. Nobody has to file a motion. Nothing has to be done except the petition is filed stamps, put into the court files, and boom, you have an automatic stay. And the automatic stay stops cold any collection activities. And that is very, very broad. So you can't foreclose. You can't repossess. You can't send threatening letters. You can't make phone calls. You can't continue your lawsuit. Your lawsuit stops. So if somebody comes into a mediation and says, hi, here's my bankruptcy petition, look what it says, and it says, stays all cases, you can't mediate the case because the whole thing has just been stayed. State court actions get stayed all the time. And the automatic stay is a court order, so you really, really, really don't want to violate it because the debtor can haul you into the bankruptcy court, who can decide to, whack you with, fines or whatever. Now, like everything else in the bankruptcy code, there are many exceptions to the automatic stay, and some of the exceptions are so complicated that they have exceptions, and it can get very difficult sometimes to parse them. Sometimes it's by accident. I will tell you one little anecdote. I was working with the National Association of Attorney Generals to broaden an exception on the automatic stay for government actions. And we had a very sympathetic Congress. I had actually testified before Congress about it. So we had someone who was willing to do it, and we were trying to broaden it to make it very clear that in addition to being able to continue a government regulatory action, if we wanted to freeze assets that would otherwise not be that could be going out the door even with a bankruptcy filing, we could do that. Unfortunately, when that language was put in, it got a little bit mangled and some words got kicked out of the code by accident, so it didn't say what it needed to say, and we actually had to, we had a case that came up in which the debtor tried to argue that it meant exactly the opposite, which was not all that unreasonable an argument because the legislative drafters in Congress had mangled a bit. And I co-wrote an article explaining all this, and fortunately we were able to clean it up a bit, but it was kind of a mess because there's a lot of double negatives and stuff, so it was not difficult to mess up. So that's just one of the things that can happen. Now, the automatic stay exceptions tend to be very deferential to family law, because of the important policies that are there. So most family law proceedings are going to be able to keep going. So you can establish paternity and domestic support obligations, child custody and visitation, and dissolution of marriage. The one exception is if you're trying to divide up property and it's not for support, but there's still a dispute about property, and your debtor has an interest in the property, so that it's property of the estate, that's going to come under the bankruptcy court umbrella, and you're going to have to do that in bankruptcy court. You're going to be stayed from doing it in your family court. Domestic violence activity is also not stayed. Continuing to withhold income under judicial or administrative orders and reporting overdue support is also not stayed. So most family law activity is fairly well protected. There are other important exceptions. I can't go through all of them because they're too complicated, but the major ones that are used are the government regulatory ones. So if there are actions going on, for example, when I was with the Securities Exchange Commission, we kept going with our fraud cases. We couldn't execute, but we could go all the way to getting a judgment against the malfeasor, and then we would go to the bankruptcy court and file a claim to collect. We would also file an action to hold that it can't be discharged in bankruptcy, but we'll get to discharge exceptions later. Eviction actions on expired leases are also accepted from the automatic stay, withholding for retirement accounts, and the swaps industry got an exception for offsetting and netting from swaps agreements so that they can, continue to unwind swaps. Now, there is a way to get relief from the stay. So what the statute provides is a creditor can come in and they can make a motion to the bankruptcy court to lift the stay in whole or in part, but they have to show cause. And bankruptcy judges have a lot of discretion to decide whether or not to lift it, particularly looking at the timing in the case. So if a secured creditor, for example, has some collateral and the debtor is just underwater, they have no equity at all, they can go in and seek relief from stay so that they can go ahead and foreclose. And if the debtor doesn't have any equity, they're likely to win that. Someone who's suing the debtor could come in and say, I want relief from stay, not to execute, but we need to be able to reduce our claim to judgment so you know that it's there and how much it is. Early in a case, they probably will not be successful. Judges tend to not want to have the debtor get distracted by all of that, so they'll probably do it later on, because otherwise they have to set up contingency accounts if there are going to be distributions for people that haven't yet established the amount of claims. So those are the kinds of things that can happen. So it is possible to get relief from stay. The more that a creditor can show that property really isn't going to help anybody else and it's just really theirs, the better they'll be. The bankruptcy discharge is an even bigger gorilla than the automatic stay because it's forever. It is a permanent order, and it bars creditors from taking any action on any of the debts that are discharged, which are going to be most debts. So whether or not you ever got a penny on it or not. So that means, once again, you can't bring legal actions, you can't continue legal actions, you do not get to send collection letters or anything like that. You violate that is a contempt action, and you get a fine and costs hit on you. So I was mediating a case about a month ago, maybe, and so the plaintiff was, your basic creditor represented by counsel. The defendant was not represented by counsel, but pointed out, well, I filed bankruptcy back, 6 months ago, and I said, did you get a discharge? Yes. So he called it up and on his phone, and shared it with the plaintiff's counsel, who looked a little flummoxed. So I put everybody into breakout rooms, and I said to the plaintiff's counsel, do you have bankruptcy counsel you can talk to? And he said, I guess I should, shouldn't I? And I said, yes, you should, because he was in a situation where he was in violation of the discharge injunction, and he didn't know about it. But as soon as he did know about it, he knew he might have to dismiss the case. And so he said, I might have to dismiss this case. I'm going to go talk to bankruptcy counsel about it. So I think that's a really good idea. And so I just terminated the mediation, and I assumed that case went away. But that's a good example of what can happen if there has been a bankruptcy discharge. Then they cannot go ahead and with the case. If in fact what happens is somebody doesn't know about the case because they weren't listed as a creditor and their debt wasn't listed and they were never given notice, even then, they are still bound by it until they get relief. They can go back to the court and they can move the court and say, look, I was left out, blah, blah, blah. I want some relief. I want relief from stay, or I want to be, included in distribution. I want this, I want that. And the court will decide what the appropriate thing is. And it really depends on what's been happening in the case. In some cases, it'll be no harm, no foul, because there's nothing for anybody to get. And so it wouldn't have made a difference. But, it's just going to depend. But, the main takeaway is that you can't violate a discharge injunction once you know about it, even if you were not given proper notice in the case. It's up to you to go back to the bankruptcy court and let them know that. Now, valid liens that the debtor hasn't gotten rid of, do ride through. So if you're a secured creditor and you still have your security at the end of the day, even if you haven't gotten relief from stay, when the case is over, either the debtor is making good on it or you're going to be able to foreclose. So that's another difference. And, why it's always better to be a secured creditor than an unsecured. I want to stop here and just see, Susan, do we have any questions on any of this yet in the chat?
Yes. What would you put on the mediator report for that? Mediation canceled. I don't think it was canceled, the mediation that you did.
No, I didn't cancel it. I terminated it.
Yeah.
Yeah, I just terminated it. I mean, I felt at that point that, first of all, there's confidentiality. So I wasn't about to spill a mediation communication on the mediation report. So we simply, had no agreement, and I left it to plaintiff's counsel, whose obligation was to figure out, what their obligation was in light of the discharge injunction and do what needed to be done.
And Molly, on that one, you put what would go on the report. It would be no agreement.
Yeah, that's what I did.
Okay.
Yeah, I mean, I'm always trying to be careful about confidentiality. Mm-hmm. With these things. It's really, it's really tempting to say something, but, basically it is up to the parties. I mean, I'm going to terminate because I'm not going to violate this stay, but it's up to the parties to take further action. And, based on my conversation with the lawyer, I am sure that he took the appropriate action because he was personally at risk. So there's nothing like that to, give people Do we have any other questions?
No other questions.
Okay, then good question, and we'll keep going with that. So we have discharge exceptions too, and there are two kinds. So one is automatic. You don't have to do anything, and you fall into that category, and you don't get discharged. And the other, you have to file a little complaint, kind of a case within a case, and that's called an adversary proceeding. So the debts that are just going to ride through and not get discharged, to some extent mirror some of the automatic stay exceptions. So you've got the family law on spousal or child support or alimony, very important. Certain types of tax claims, fines and penalties imposed by governmental units. I used that a lot. If you have government guaranteed loans or benefit overpayments, personal injury caused by drunk driving, amounts owed to certain tax advantage retirement plans, and certain condominium or co-op fees. Some of these you can see a public policy reason. Some of them are because interest groups got their legislation passed, and there are lots of interest groups that are constantly wanting to get either exceptions to the automatic stay or to discharge or to get priorities and things like that. So every time the bankruptcy code's up for revisions, these are the areas that there tends to be a fair amount of pressure from interest groups on. And so it is a bit of a patchwork sometimes. Now, here are the exceptions that require a creditor to file an adversary proceeding. I have done that a lot. The one that I've worked with the most is debts arising from fraud. We had a whole program at this at the SEC, and so did lots of other governmental entities. Another category is debts arising from fiduciary defalcations. What that means is fiduciary misconduct. So if you're like a trustee of a trust or something like that, and you engage in self-dealing, something like that would be a debt arising from a fiduciary defalcation. And also debts arising from willful and serious injury by the debtor to another or to the property of another. And that one, you may see that in some of your mediation cases. I saw one recently where there was a case involving injury to the property of another, and not clear if we're talking negligence or gross negligence or recklessness or whatever, but I could tell that counsel was thinking that if they lost the case, they would just file bankruptcy. And I don't think had really thought about the fact that it might potentially be a non-dischargeable claim. It didn't really matter because it was not a case that either party was prepared to settle, but I could almost watch this little calculation going through. Sometimes what you may see if you look at a case file and you see that there has been, and this is mostly in county civils where I've seen this, where there's discovery going on and the defendant is never complying and always forcing the plaintiff to file motions. And so as a result, they are making it take longer and be more expensive. And, kind of like, fine, we'll roll the dice. We're going to make this miserable for the plaintiff. And even if they do go through the whole thing, we can always file bankruptcy. So you may see that. I think I saw that recently. That's what I thought was going on. And, there's not a whole lot you can do in those situations, but if counsel are on their toes, they will know about this exception. Other discharge limitations. There are a lot of disclosures that have to be made, a lot of cooperation that debtors have to make in a case, with their trustee or with the U.S. trustees, and, file information that creditors can see as well, so that you can see what the debts are, what's owed, what's disputed, what's not. The books and records need to be available. Everybody needs to know, what assets are actually available. And you're not going to get a discharge if you don't cooperate, if you don't follow the rules of the court, if you don't obey the orders of the court, if you don't show up for things, if you destroy your records, if you hide your records, things like that. And even if you don't get caught during the case, if a creditor, finds out after the fact that, you committed fraud in the bankruptcy case or you concealed an asset, then there's a time period within which somebody can go back and move to revoke the discharge, and then everything, comes back to life. Another thing that can happen in really bad cases is, a referral to bankruptcy fraud. And I had a fairly notorious securities fraud defendant who after losing his cases with us, filed bankruptcy and then proceeded to commit bankruptcy fraud, hiding assets through shell companies and running them through some friends. And I actually tracked some of the money that he had sent overseas came back down to Florida. Actually, this is a New Jersey case, and was invested in one of those cruise to nowhere ships on the Atlantic side, and through a bunch of friends and lawyers and a bunch of other things. And it took a good subpoena trail to find it, but I did find it. And that was one of several things that I referred over to the U.S. Attorney's Office, along with concealing various trusts, some foreign trusts and things they set up. There was a prosecution for bankruptcy fraud that I assisted in, and he was convicted. And that's what he went to jail for, not for the securities fraud, which was a civil case, but he went to jail for about 5 years for the bankruptcy fraud. So this is pretty serious stuff. Let's talk about types of bankruptcy. Now, there are 6 types. I'm only going to talk about 3 because I don't think that you are going to see the other 3. I haven't seen all 6 of them in many years of practice. I've seen 5 of them and very rarely them. So Chapter 7, liquidation, which we will talk about, which is just what it sounds like. Chapter 9, adjustment of debts of municipality. You probably have read about the Detroit case. That's probably the most famous one we have, but you're very unlikely to see that. Chapter 11, reorganization. You may see that probably with small businesses. Chapter 12, adjustments of debts of family farmer or fisherman. Unlikely to see that. I've never seen a Chapter 12. Chapter 13, we're going to talk about that, adjustment of debts with individual and regular income. And then Chapter 15, ancillary and other cross-border cases. I've worked on some of those, but those are international bankruptcies. So where you have really large international companies, the code does have ways to coordinate across countries. So, for example, we had the Nortel bankruptcy where there was a proceeding in Canada, there was a big case here, and there was a case in the UK, and we had to coordinate all of them. So that was interesting. But you will not see that. You will see 7, 11, and 13 if you see any of them. So we will start with Chapter 7, liquidation, and that's the most common, although that may be changing over time with the 2005 amendments. So who can file? Individuals, corporations, or other business entities. So basically, it's all about just winding up your affairs and distributing all your assets. If you're a company, you just go in, trustee takes over, whatever there is goes out, and then you're gone. If you're an individual, there is now a means test, and that was put in with the 2005 amendments to the code. There didn't used to be one, and there was concern that wealthy individuals were taking advantage of that because they could go in, and even if they had a large income, they could shield it because property of the state in a Chapter 7 is only the assets that existed at the time of the filing. So if someone is making money afterwards and has a large salary or whatever, it's not. Part of the estate is not available for distribution to creditors. Therefore, Congress amended the code in 2005, and there is a means test. And if your income is too high, you're not going to be able to be in 7. You'll have a choice of either converting to Chapter 13, or you make payments out of disposable income, or getting dismissed. And the most recent numbers I looked at were basically if your aggregate monthly income over 5 years is more than $12,850 or 25% of your non-priority unsecured debt, as long as that amount is at least $7,700. So, Chapter 7 is really for people that don't have very much income to devote to creditors, because they're going to go in and probably out very quickly. The trustee is appointed. The trustee is going to gather all the non-exempt assets and distribute them to creditors along, the priority listing. So the secured creditors will get whatever security they have. The unsecured creditors will probably get nothing. And in fact, many Chapter 7s are no asset cases. And I don't know, Marjorie, when you were doing work for the Collins Center, did you see a lot of no asset cases? We need your mute button off.
we did the mediation, and it was, we didn't get that involved. It was the attorneys for both sides. And so I'm just telling you that as a mediator, I didn't get into that. It was presented, and the purpose of us being there was for us to try and get the bank and the lawyers to agree on, to agree on a certain amount of money, and we could lower the interest rate to as low as 2%. So the focus was, that was the focus.
Okay, I know what those would have been. Those would have been Chapter 13s then, to get people to be able to keep their houses, and we will get to that. But I was picking on Marjorie because she had told me before we started that she had worked on a project at the Collins Center after the last recession, not this one, where mediators came and helped out in bankruptcy cases, and I was very impressed by that. So I thought I'd put you on the spot a little to hear what you were doing, and that's very relevant to a later slide, so I may ask you again later to tell us a little about it. But in Chapter 7, a lot of these cases are no assets. So there's no property that's not exempt to be distributed. The trustee will look to see if there are any claims. Maybe there's been an accident and they've got a claim against somebody, or some other kind of claim. But if they don't have them, then the trustee is going to close the case pretty quickly. And the Chapter 7 discharge is subject to all of the exceptions that I showed you on the prior slide. So Chapter 7 tends to be fairly quick. They're always going to be fairly low asset and people that do not have much of an income. So a lot of the people that you will see in these cases will be the kinds of people that you see in these debt collection cases, where they are overwhelmed with debt from lots of credit cards, this, that, and the other, and don't really have very high incomes, or maybe they've been laid off, or that sort of thing. And that's really the kind of person that Chapter 7 can help with a fresh start. Chapter 13 is called the Wage Earners Plan, and that's for people who have a regular income above the level that I told you about for Chapter 7, and whose debts are within a manageable limit. Right now, the limit is, and they change with the CPI. So the current one, just to give you an example, your unsecured debts have to be less than $394,725, and your secured debts no more than $1,184,200. So, there's room for a fair amount of debt. And this is only for individuals, because this is really, the point is to take the debtor's disposable income and create a plan to pay off creditors some portion of what is owed over the next 3 to 5 years. So they're probably not going to be made whole either, but it's a lot better off than in a Chapter 7, because whatever income the debtor has beyond what they need, for their normal living expenses, will go into a plan, to make installment payments to creditors. So this actually, if you have a dispute between two parties, and the most of the debt is really just from this one two-party dispute, and someone thinks they can file bankruptcy and basically wipe their creditor out, if they have a decent income, they'll probably end up in Chapter 13, and the creditor could actually be better off, because they're going to have to devote disposable income to an installment plan to pay them off. So sometimes this can actually be helpful to a creditor. Now, what is what can really induce somebody to go into 13 and go through this, which is not an easy process, is that you can cure delinquent mortgage payments. So the way this works is, if you're delinquent on your mortgage and you file Chapter 13, you need to come current with all of the payments that are due during the case. But for those that you've already amassed, all the arrearages from the past, you can put them into an installment plan. And as Marjorie said, they can negotiate the interest rate, can negotiate the terms. But as long as you stay current during the case and you have a plan to be paying off your mortgage, you can do that. So that that can be a big deal to people that want to keep their houses. That can be a great boon to them, and it does help the creditor to get some payments. So that's really what motivates people to go into Chapter 13. Did you have anything that you could tell us about your experience in negotiating these things, Marjorie?
Well, I also did mediations in the federal bankruptcy court.
Mm-hmm.
Most of those were Chapter 13s, and that is really where, where the work was done, and the sole purpose was to try and keep the house. And so, that's, I mean, the mediations were a lot of negotiations as to what, the creditors, what they had coming to them, and the debtor, what income did they have, what income could they produce. It was just a lot of negotiating. So.
Well, thank you, Marjorie. That sounds like a really helpful program. Now, Chapter 13, includes the debtor's post-petition income. So that's the big difference between 13 and 7 is that, someone who's earning a regular income, that is, in fact, property of the estate, which means that, after you make your payments for your living expenses, you have a definition of disposable income, and that's got to be devoted to paying your debts. But, so it's got a kind of carrot and stick. The stick is that, you have to make these payments, which, people are kind of, but the carrot is, you get to keep your house. And that's a big deal because, normally if you don't have the equity, then you don't have the homestead exemption. So that's important. The other thing to know about Chapter 13, the more carrots, is that the automatic stay provision is broader. So if you have a consumer debt and you've got somebody else that's, a co-debtor or someone that's guaranteed it, whether it's a spouse or a parent or a sibling or whatever, they also are subject to the automatic stay. And the reason that Congress put this in is because they didn't want creditors to be able to pressure the debtor indirectly and do what they can't do directly. So if you can't pressure the debtor because of the stay, you shouldn't be able to pressure them by putting pressure on, their loved ones or somebody else that's liable that's going to then, put the arm on them. That's only for the automatic stay. That's not for the discharge. The discharge is only for the debtor. So it's only going to protect the co-debtor during the pendency of the case. Now, the other carrot for going Chapter 13 is that there are a couple, you get what we used to call the super discharge. And so the super discharge means you can discharge debts that you can't discharge in a 7. That includes the willful and malicious injury to property, some tax obligations, and very important, the property settlement that is already exempted from automatic stay even in Chapter 7. The non-support obligations are discharged. So if somebody is still negotiating, property distribution, it's going to end up being rolled into the Chapter 13 plan, and that's all they're going to get. So there is that. And, once again, that's an inducement to get people to come in and take on the obligations of doing a plan, which Congress felt was, much better for society to do than to just have people go into Chapter 7 and not really pay anything. Any questions about Chapter 13? Alrighty, we'll keep going, but anytime something comes up in the chat, Susan, just let me know. So in Chapter 13, oh, did you have something?
Nope, there's
Okay.
no questions.
Okay. There is a hardship discharge. So let's say the debtor's been going along paying Chapter 13 payments in their plan, and they're in year 2 or 3, and a pandemic happens, and they lose their job, and they lose any opportunity to get another job, and so they no longer have disposable income, and they can't continue to pay. In that case, they could go to the court and say, I want to discharge anyway, and the discharge, it's not my fault, and, I can't even go out of my house, I'm at risk, I'm diabetic or whatever, so I can't even do that. So the court might say, okay, I'm going to give you a hardship discharge, even though you didn't complete your plan, but you don't get the super discharge. So you get the Chapter 7 discharge, which means that you're not going to discharge those tax obligations, you're not going to discharge the property settlement obligations, etc. So, it's always a balance. Now, less common than the other two, but still where most companies, and certainly the large ones and some small ones will start out in, although they may not finish, is Chapter 11 reorganization. And all the big cases that you read about in the newspaper, like Sears, for example, which I and my agency were very involved in, those are Chapter 11. And individuals and business entities can both file. But when you file, you're not a debtor, you're a debtor in possession, and that term is there to show that they're keeping possession and control of their assets. So unlike the other chapters, initially there is no trustee, and there won't be unless there is misconduct or just incompetence shown by the debtor in possession. So when a company files bankruptcy, its management continues in control. And it can hire counsel, it can hire reorganization professionals, it can hire financial advisors, et cetera, with the approval of the court, and they're paid for from the estate. And guess what? These are priority claims coming ahead of all the other creditors. So, big Chapter 11s can have huge administrative claims. One of the things we were always concerned about, and in fact happened in Sears, was that with all of the different advisors that were being paid for, it would become what's called administratively insolvent, which meant that not only was there not going to be money for the creditors, there wasn't even enough money left to pay all of the administrative claimants, all these lawyers and accountants and this and that and the other. And, that can happen sometimes, and it shouldn't. And the bankruptcy courts and the U.S. Trustee's office are looking over everyone's shoulder to try and keep this from happening. So the point of Chapter 11 is really to create a plan of reorganization. The plan of reorganization is something that all the creditors, get to vote on, majority vote, although majority is not what you might think, and then it gets confirmed by the bankruptcy court. And this is a negotiated process. So a Chapter 11 is many, many, many negotiations between and among creditors, and then between the creditors and the debtors and the secured lenders and the unsecured, and everybody is sort of trying to figure out how to come up with a plan that lets this thing, keep going, get people paid somewhat either now or later if they're going to end up being owners of this company at the end of the day, because the stockholders are probably going to be out of the money and gone, and someone else is going to own this company. So property of the estate, in a Chapter 11 for companies, it's like Chapter 7, it's just whatever is owned when they file. But if it's an individual and individuals can file Chapter 11, then it's more like a 13. And a wealthy individual with lots of business interests that goes into Chapter 11 individually, and has all their companies and stuff, whatever they're drawing out to pay themselves, that is also property of the state. And I am proud to state that that is a legal change that I fought for pretty hard after dealing with fraudulent debtors with multi-million-dollar, fraud claims against them who were paying themselves, $1 million to several $1 million out of their companies that was not available to creditors, in which they were not accountable for. So I worked with a bankruptcy judge and others to put together some recommendations to Congress, which were enacted. So that what didn't used to be the law, but it is the law now, that if you're an individual in Chapter 11, your post-petition income is property of the state and it is available for distribution to creditors. Another big difference in a Chapter 11 is that there is another player called a creditors committee, and it's the unsecured creditors committee, or UCC. And under the law, it is presumptively going to be the unsecured creditors with the 7 largest claims that are unsecured. It may be 5, it may be 9, it depends on the size of the case. The unsecured creditors committee gets to hire their own lawyers. They get to hire their own professionals. That might be, turnaround specialists or, investment bankers, whatever. And they get paid from the estate too. And guess what? They're priority claimants too, ahead of all of the creditors. So you can see how these things can get expensive. That might not happen in a small business case. In small business cases, there may not be large, sophisticated, unsecured creditors that want to spend the time sitting on a creditors committee. And so there are special provisions for small businesses that are defined by the code, and the U.S. Trustee's Office provides the oversight that would normally be provided by an unsecured creditors committee. And it's likely, if you see 11s in our practice, they will probably be small business cases. So here's how the reorganization process works. The debtor in possession has the sole right. They're in possession, they're in control, so they're the only ones that can propose a plan during the first 120 days, and they can get extensions up to 20 months from the court, but they have to ask the court for it. Everybody can object, and then the court decides. So the way the process works is once they have a plan, which hopefully they have negotiated with everybody else and sort of gotten some idea that it's acceptable, they file what's called a disclosure statement, which is supposed to be in plain English, and it's supposed to explain to everybody, you know, how their claim's going to be classified and how they're going to be treated, so you can figure out what you're going to get. So if you're an unsecured creditor and you're in this group of unsecured creditors, everybody's going to get, you know, 10 cents on the dollar. You're a secured creditor and your security is sufficient. Either they'll cure all their arrearages and, you know, hold on to the collateral, or, you know, you'll be able to get your collateral. So, you know, the statement has to tell you all that stuff. There's always litigation over disclosure statements. They always have to be amended. Eventually it goes out and everybody votes. And in order to, voting is not, you know, one person, one vote. Instead, first of all, you have to have an impaired class that accepts the plan. What does impaired mean? You're impaired if you're not getting 100 cents on the dollar. So if you're in a class and everyone is getting 100 cents on the dollar, they're all really happy, but they don't get to make the decision for the people that are not. So you're going to have at least one impaired class vote to accept the plan. It's like, okay, we're getting 50 cents on the dollar. It's a lot better than we would do if there was a fire sale and liquidation, so let's do that. But the way that you actually have to have a majority is the majority, you have to have affirmative votes of at least 2/3 of amount in a class. So if you have a class of claims of $1 million, you need at least $667,000 worth of those claims to vote in favor. And if you have 5 people in the class, you're going to need to get, you know, 3 of them there to vote, because you need more than 1/2 in number. But as long as you can do that with one impaired class, you can get to the next stage, which is the court holding a hearing on confirmation. And then what the court has to do is make findings that the plan is feasible, proposed in good faith, and is compliant with the bankruptcy code. And feasible generally means that, you know, it's not such a pie in the sky thing that we think that 2 days later you're going to come right back in bankruptcy because you can't afford to do what you've said you're going to do. Good faith means obviously you are not, you know, aiming it at others. And under the bankruptcy code, there's a liquidation test. So that means that under a plan of reorganization, you have to do at least as well as you would if it was a straight liquidation and you just took all the assets and whacked them up under the priorities. You know, that's the bottom line test for everybody. You've got to be able to meet that test or you're not going to be able to confirm the plan. So once a plan is confirmed, the debtor in possession then makes the plan payments. They're bound by the provisions. It's a brand new contract. It takes over from any of the old contracts that happened, you know, before the case was filed. And if the debtor in possession doesn't get a confirmed plan and time runs out, the unsecured creditors committee might propose a plan, or a major creditor might propose a plan. But they still have to follow all of those same steps, whoever does it. And every once in a while, there are competing plans that you get to vote on. And if you're an individual in Chapter 11, you are subject to the same discharge exceptions as under Chapter 7, but that is for individuals. You know, companies are, you know, out free and clear. One other thing I'm going to mention, although it's somewhat rare, but, you know, I have seen this happen once or twice, and it's just something to know about, is that even if the parties in front of you have no intention of filing bankruptcy, if a person or a corporation is not paying their debts and people are worried that they're just going to spiral out of control before they can get their hands on some of the money, there is the option of filing an involuntary petition under 7 or 11. You can't file an involuntary 13. There was concern that making somebody, you know, work for their creditors smacks too much of involuntary servitude, so you can't do that. But you can put individuals into 7 or companies into 11. But if you're a creditor and you file an involuntary, it doesn't automatically create a case. The debtor can object, and the court's going to have to rule on the objections. If they don't object, you know, they can always turn it into a voluntary too. This doesn't happen very often. There are thresholds for creditors, so if you want to bring somebody into an involuntary, then you have to have a pretty well-established claim. It can't be contingent. So if you're in litigation with somebody, you can't shove them into involuntary bankruptcy. But if you have a judgment and it meets all the other requirements for an involuntary, then you might be able to do that. It's just something to be aware of in cases where someone's got a really shaky company that isn't paying its debt and might be on the verge of taking on some more, and that could trigger an involuntary. But it is pretty rare, but it is just something to know about. I mentioned a little bit earlier about dismissals for abusive process. There are several different things that can happen to a bankruptcy case where it doesn't run its course. Conversion, dismissal, or reopening. So a bankruptcy court can convert a case either on motion or if it thinks it should convert it. So, 11s get converted to 7s when it's clear that liquidation is the only course and there's just no way to reorganize. Sometimes the 7's going better, it might convert to 11. That's pretty rare. 7s, as I've shown, get converted to 13s when they're really not eligible to be in a 7. A 13, where somebody lost their job and hadn't gotten to the plan yet for urgent discharge, might convert to a 7. So you can kind of, bop back and forth. If someone does get their bankruptcy case dismissed for misconduct, they're going to be barred from refiling for 180 days. So that's a good thing to know. If a bankruptcy has been dismissed, that's not going to be an option for somebody for at least 180 days. The other thing that can happen is a court can reopen a bankruptcy. So, for example, in the case I talked about before, where there was a bankruptcy discharge and someone was proceeding with their case, and the case was over, the debtor could have gone back to their bankruptcy lawyer and said, reopen the case, let's nail these guys. I don't believe they did that, but it was certainly something that could have happened, and it is a risk. A creditor could also go back. As I said, if the creditor wasn't notified of the bankruptcy, the debt wasn't scheduled, maybe they have a fraud debt, and so they want to be able to file an adversary proceeding to show that it's not subject to the discharge. They might not, if it's just a no asset case and they have a dischargeable debt, it really won't matter very much, though. So it just depends on the type of debt that they have. The final subject I'm going to talk about is avoidance actions. And this is something that more sophisticated creditors, which we see in a lot of our collection cases, banks, for example, or other kinds of insurance companies and things like that, might think about this. We thought about it all the time when I was in practice with an agency. Which is avoidance actions. And an avoidance action is part of serving the goal of equitable distribution. That means that the bankruptcy code does not look kindly at last-minute attempts to favor some creditors over others when a debtor is circling the drain to insolvency or is actually there already. So there are two types, and the first is called a preference, because that's a case where the debtor is preferring to pay one creditor when they're not paying others. And the general rule, subject to lots of complicated stuff I'm not going to get into today, is that payments made to creditors within 90 days of filing a petition can be avoided as preference. And what that means is that the money has to come back, and the creditor then stands in line like everyone else. If they're non-secured, they get paid in bankruptcy dollars instead of the 100 cents on the dollar that they got from getting a preference. There are exceptions, of course, to the preference actions. The two most used ones would be ordinary recurring payments. So, you're just paying on a regular basis and it's just every week or every month or whatever. And those are just, ordinary course payments, and those are not preferences. Or where new value is given. So if I've got a debt already, but then I give you something new, we have another exchange for value. And so you pay up the debt in exchange for what I gave you, then that's an exception. It's 90 days for regular creditors, but if an insider of the debtor gets paid off within a year of the petition, that can be a preference. So that is something, if you're a creditor that is dealing with a financially precarious debtor and trying to negotiate a settlement can be concerned about that. And we'll talk about what you could do in a minute, because I'm going to talk about the other type of avoidance actions. And there are other kinds of things involving liens and strong arm powers I'm not going to get into because they're not quite as pressing and things that you'll run into. But fraudulent conveyances are basically when payment is made and it's not in exchange for reasonably equivalent value. And that means like a sweetheart deal, or somebody pays, a whole lot for something of dubious value, or if they're making payments that cause them to become insolvent. Someone is transacting and they are clearly at the end of their financial rope, but they make a big investment in something anyway. That could be a fraudulent conveyance. State law usually gives us the rule of decision. So basically be like in Florida, it'd be a Florida fraudulent transfer law, and that will also tell you how far back in time you can go. Some states have 3 years. You can go back and look at transactions for 3 years from the filing. Some, 4 or 5, some only 2 or 1. So it just depends on your state. What is important to know about avoidance actions is that sophisticated parties try to build into settlements of protection. And that is something that we obviously thought about a lot since we were dealing with companies that could no longer afford their pension plans at my agency, the Pension Benefit Guarantee Corporation. And so we had to think about, if we go ahead and collect what they owe us for taking over their pension plan, what's going to stop a bankruptcy case if it's filed in 90 days from coming after us? Then our whole, and then we have the worst of both worlds, because we have agreed on a settlement amount that is not the full value of our claim in order to get paid, and yet that's what we would be stuck with if we didn't do something about it in the bankruptcy court. So we have to give the money back, and then we'd get paid with bankruptcy dollars, which is, cents on the dollar for a lowered claim, the amount we settled by. So one of the things that you can do that does not violate the ipso facto clause prohibition is to say that, we're going to release our claim in the full amount in 91 days. And, if a bankruptcy happens in less than 91 days, then we're just not going to go forward, and our claim will be what our claim is, and we'll make our claim in bankruptcy in the full amount as opposed to some discounted amount. So that's something that, a bank or insurance company or something like that, they may ask for something like that if they're dealing with someone that they're very concerned about. And that would not be something unreasonable for them to ask about. So what I have tried to get across in this presentation is that, bankruptcy can involve a simple no asset liquidation. It can involve a complex corporate reorganization. But no matter which range of the bankruptcy spectrum you're at, it's going to radically alter existing financial relations. And the fact of a bankruptcy or the contemplation of a bankruptcy is something that the parties, particularly, if they're counsel there, are going to be thinking about, what's my alternative? How do I fare if, I file bankruptcy or the other party files bankruptcy, as part of the calculus, and understanding that, and also understanding how to behave if there's been an automatic stay slap into place or a discharge injunction to avoid getting in trouble. Those are things that are important to know about and consider. And I think that understanding all of this and being alert for it can help us all be better mediators. So I'm happy to take any questions now. Just,